Welcome to this explainer. Today, we're diving into the surprisingly reluctant, messy, and honestly fascinating creation of the United States Bill of Rights. Is the document that literally defines American freedom today, but its journey into existence, well, it was anything but straightforward.
To kick things off, let me ask you a seemingly simple question, one that actually hides a pretty wild political backstory. Who wrote the United States Bill of Rights? Take a second and really think about it.
You probably guessed James Madison, right? The brilliant thinker we often call the father of the Constitution. But here's the kicker. Madison originally hated the idea. Seriously, he couldn't stand it. In fact, during the Constitutional Convention back in 1787, when a Bill of Rights was first brought up, Madison and a unanimous block of state delegations completely voted it down. No way.
Now you might be wondering, why would they oppose it? Well, fellow Federalist Alexander Hamilton hit the nail on the head in Federalist number 84. He argued that bills of rights were not only unnecessary, but outright dangerous. And their logic kind of makes sense when you think about it. If we make a specific list of protected rights, future leaders might just look at that list and say, well, if a right isn't explicitly written down right here, you must not have it.
Okay, let's look at our roadmap for today. To see how this foundational document came to be, we'll cover the reluctant architect, the great ratification debate, the cutting room floor, the 10 amendments, and finally, a living legacy.
Section 1. The Reluctant Architect, focusing on Madison's initial opposition. Let's dig into why the primary author of these rights was originally so dead set against writing them down.
You see, Madison famously dismissed the existing state-level protections as mere parchment barriers. He genuinely believed the new Constitution already restricted the federal government to just a few and defined powers. His thought process was basically, if the government doesn't even have the power to infringe on free speech or religion in the first place, then a flimsy piece of parchment declaring those rights is completely redundant. Honestly, he felt it offered nothing more than the illusion of protection against a real tyrant.
Section 2. The great ratification debate between the Federalists and Anti-Federalists. Because to get this Constitution actually passed, Madison had to step out of the theoretical clouds and face a massive, very real political conflict over the very soul of the new nation. The absolute crux of this conflict was a heavyweight clash between the Federalists and the Anti-Federalists. The Federalists desperately wanted a strong central government to hold the young country together, and they felt the Constitution was perfectly sufficient as is. But on the other side, the Anti-Federalists were terrified. They looked at the powers of the new president and essentially saw a potential king. So they demanded explicit protections for individual liberties and literally threatened to block the entire ratification of the Constitution if they didn't get them.
Facing immense pressure from the Anti-Federalists and getting a heavy nudge from his close friend Thomas Jefferson, who was over in France at the time, Madison finally realized he had to bend. Jefferson essentially gave him this incredibly practical advice. Half a loaf is better than no bread. If we cannot secure all our rights, let us secure what we can. So, Madison compromised. He agreed to the Massachusetts Compromise, promising to introduce a Bill of Rights immediately in the first Congress, but only, and this is absolutely key, only if the states agreed to ratify the Constitution first.
Moving on to Section 3, the cutting room floor, where Madison starts whittling down the demands. Once the Constitution was ratified and Madison was actually elected to the House of Representatives, after a surprisingly tough race against future President James Monroe, by the way, he had to honor that campaign promise. He had to actually write the thing. So welcome to the cutting room floor.
And man, did he have his work cut out for him. He had hundreds of state recommendations to sort through. Just to give you an idea of the sheer volume we're talking about here, a committee from the Virginia Convention alone forwarded 40 different recommended amendments. 40. So Madison sat down, pulled from his deep knowledge of state constitutions and historic documents like the English Magna Carta, and just started synthesizing.
Madison originally wanted to weave these amendments directly into the text of the Constitution itself, but Congress decided it was better to just tack them on to the end. The legislative process was pretty brutal. Step 1, the House of Representatives approved 17 amendments. Step 2, the Senate got their hands on them, heavily edited them, and condensed them down to 12. And finally, Step 3, those 12 were sent out to the states, and by December 1791, the states had officially ratified the 10 amendments we all know today as the Bill of Rights.
But wait, what about those other 2 amendments, the ones that didn't make the cut in 1791? Well, incredibly, one of those original 12 proposed articles, which actually dealt with congressional pay, became the 27th Amendment over 2 entire centuries later.
It sat completely dormant until a college undergrad named Gregory Watson started a massive letter-writing campaign. He literally got it fully ratified in 1992. Pretty wild, right?
All right, Section 4, the 10 amendments. Let's do a quick breakdown. We're going to logically group the 10 ratified amendments that did make it through in 1791, just so we can really grasp exactly what they protect in our day-to-day lives. This first grouping covers your most fundamental rights, the rights to think, speak, publish, and gather completely freely. The First Amendment is really the absolute cornerstone of American civil liberties. It ensures the government cannot establish a religion, they can't stop you from practicing yours, and they definitely cannot silence the press or shut down peaceful protests.
Next up, we see explicit protections for personal security, alongside very strict limits on how the government can actually investigate you. The Second Amendment protects the right to keep and bear arms. The Third, which was born directly out of colonial resentment toward the British, stops the government from forcing you to house soldiers in your own home. And then the Fourth and Fifth Amendments step in to ensure you're protected from random, unreasonable searches, and they absolutely guarantee due process of law if you're ever accused of a crime.
Now, if you are charged with something, the Sixth, Seventh, and Eighth Amendments are there to ensure the justice system plays fair. They guarantee a speedy and public trial with a lawyer, they ensure you get a jury trial even in civil disputes, and they absolutely forbid the government from imposing excessive bail or dishing out cruel and unusual punishments.
Finally, we get to how Madison brilliantly solved his own original dilemma. Remember that huge fear Hamilton had about a list being dangerous? Well, with the Ninth and 10th Amendments, Madison essentially created a giant catch-all safety net. The Ninth Amendment basically says, hey, just because a right isn't explicitly listed right here on this paper doesn't mean that people don't have it. And the 10th Amendment guarantees that any powers not specifically assigned to the federal government, those belong exclusively to the states, or directly to you, the people.
Section 5. A living legacy and the slow awakening of the Bill of Rights. This final section explores how these centuries-old rights actually ended up impacting American life. Because the crazy truth is, their impact was definitely not immediate. In fact, for the first 150 years, the Bill of Rights was practically dormant legally.
Yeah, you heard that right. For over a century, the courts, most notably in the 1833 case Barron v. Baltimore, ruled that these 10 amendments only restricted the federal government. That meant your state could technically violate your freedom of speech, and the Federal Bill of Rights couldn't do a thing to stop them. It wasn't until the 14th Amendment was ratified after the Civil War that the door finally opened for a legal process known as incorporation. Starting really heavily with the Gitlow decision in 1925, the Supreme Court finally began applying these fundamental rights downward to state and local governments too.
Fast forward to today, and these rights, and honestly the physical documents themselves, are culturally revered. George Washington originally had 14 handwritten copies made. And get this, North Carolina's original handwritten copy was actually stolen from their state capitol by a Union soldier right after the Civil War. It was missing for over a century. It was finally tracked down and dramatically recovered by an actual FBI sting operation back in 2003. Sounds like a movie, right?
Which brings us right back to the present day. The Bill of Rights was explicitly designed to withdraw our fundamental liberties from the ever-changing winds of politics. So as we wrap up this explainer, I want to leave you with a provocative thought to consider, specifically zooming in on that Ninth Amendment. As technology and society continue to evolve at lightning speed, what unwritten rights do you think need protecting in our modern world? Let that sink in for a bit. Thanks so much for joining me on this deep dive, and as always, keep asking the big questions.